Hi, everyone. Thank you so much for joining our call today. We are right at 12:30, so we are going to go ahead and get started. Just a few quick housekeeping things. Everyone is on mute, and that is on purpose so that we can hear all of our presenters. We will be doing a Q&A in the later portion of the call. If you are joining us from your computer, please pop your questions into the chat box and we will either answer them on this call or we will get back to you later. If you are if you've got questions about your individual case, feel free to email those questions to intern@aclumich.org. We are not able to answer those individual questions about individual cases on this call, but if you shoot us an email, we will be able to get back to you with more details. And finally, if you are not joining us from our computer and you've got questions, please call us at 313-578-6829, and we will record your question and ask it to the folks on the call as well. And finally, we are going to be posting a recording of this call tomorrow, February 18th, to aclumich.org/en/SORA. And we will be sure that y'all have access to that as well. And now, to kick it off, I am going to introduce Miriam Ackerman, who is an attorney at the ACLU of Michigan. Miriam, you are unmuted.
Hi, everyone. I'm Miriam Ackerman. I'm a senior staff attorney here at the ACLU of Michigan, and I'm joined today by Paul Weingold from the University of Michigan Clinical Law Program and Allison Oliver from the Oliver Law Group. We are some of the attorneys who are involved in litigating this case. And so we wanted to take the opportunity today to tell you a little bit about what the decision means for you and to answer some questions that you might have. So we're really excited. It's a great decision. It's a tremendous win for public safety and for all of you, for Michigan families. So we're very excited about it. There's going to be a lot of information on the call today. And I want to focus on a couple of things at the beginning, because if you only remember those couple of things, those are the most important things to remember. First of all, the decision is not yet in effect. It is likely to go into effect in about 3 months, but it could be longer than that. And until that happens, until either the decision goes into effect or the legislature passes a new law, registrants should stay compliant, to continue to follow their obligations under the statute until that happens. So that's the first really important thing. The second thing is that the decision basically gives the legislature a couple of options. They can either rewrite the law or they can not enforce the existing law. And so if this is a real opportunity to get a new and much better law, but if the legislature passes a new law and the new law is constitutional, you may still be required to register. Many people will still probably be required to register. What we need from you is that you and your families come forward and help us work towards a new evidence-based law that is much better than the one that we currently have. And finally, the third point that we want to make sure everybody understands is what this decision means for you depends on when your offense was. So people with offenses before April 12th of 2011 are different than people with offenses after that. So let me just give you a little bit of background about the case. The Doe's 1 case, which is the initial case, was filed back in 2012, and it was for a couple of individual people. And we had a number of different claims in that case. We lost the ex post facto claim, which is that you can't apply the law retroactively in front of Judge Cleland, but we won a number of other claims in front of Judge Cleland. And then both we and the state of Michigan appealed the parts of the case that we lost. That went up to the Sixth Circuit Court of Appeals, and in 2016, the Sixth Circuit Court of Appeals said that the 2006 and 2011 amendments were unconstitutional. And just so people know, the 2006 amendments were the amendments to the law that create geographic exclusion zones that limit where registrants can live and work, and so-called loiter, which is basically spending time, often can involve spending time with family. And then the 2011 amendments were a total rewrite of the registration statute. They divided registrants into tiers. Those were posted publicly. They required extensive reporting requirements, and they lengthened the registration terms for many, many registrants to lifetime. And those are the two sets of amendments that the Sixth Circuit Court of Appeals said couldn't be applied retroactively. The Sixth Circuit didn't decide all the other issues in the Doe's 1 case. It just decided the ex post facto issue. And the Supreme Court didn't take the case. So we thought at that point that surely the legislature was going to pass a new law because the law had been declared unconstitutional, but that didn't happen. So then we, along with the Oliver Law Group and again the University of Michigan Clinical Law Program, brought a class action lawsuit. So a class action, that's the Doe's 2 lawsuit. A class action lawsuit, basically, the way that works is that a couple of people bring a case and it affects everybody. It's on behalf of a whole group of people. And we brought the Doe's 2 case on behalf of everybody on the registry, and there are also subgroups within it that relate to people whose offenses are before 2006 and before 2011. We brought a number of different claims under that lawsuit, and we'll talk about those in a minute. Okay, so on Friday, what happened is that the court ruled on all of the claims that we brought in the Doe's 2 case. I think what's very important is to understand that the ruling is not yet in effect. So you need to stay compliant with your registration obligations until either the ruling goes into effect or until the legislature passes a new law. In terms of how much time there is, the ruling could go into effect in approximately 3 months. Basically, the way the court set up its judgment is that the lawyers have until the middle of March to prepare, or the court set up its opinion, is that the lawyers have until about middle of March to come up with a written judgment, which is basically a written order. And then it could take some time for the judge to enter it. He could enter it that day, or it could take some time depending on whether he has questions about it. And then the order is supposed to have in it that 60 days till it's effective. So we're talking at least 3 months until there's until the decision would go into effect, possibly longer than that. What's also very important to understand is that this ruling doesn't mean that there can't be a registry. What it means is that if the legislature does not write a new law, it can't enforce the current one at all against pre-2011 registrants, and it can't enforce parts of the law against post-2011 registrants. So who will ultimately have to register and what their obligations are going to be will depend on what new law gets passed, if a new law gets passed. The Doe's decisions set very important limits on what a new law can look like. So it's important to understand that the legislature just can't pass the same thing all over again. They have to make changes in light of the court decisions that make the law a lot less restrictive than it is. And at the same time, it's important to understand that courts have upheld what we call first-generation laws, which are simple registration statutes. And where I think the real difficulty is going to be is between the sides is sort of what we think is unconstitutional and what the state thinks is recognized as unconstitutional may not be the same thing. I think the other important thing is that this is a real opportunity to have an evidence-based statute. Because we know that registries don't work, they're counterproductive, they're ineffective, we have a very bloated system. And so this is a real opportunity for us to actually get a law passed that is based on what the research shows, what the evidence shows. Okay, so let me talk briefly about what the court ruled for everybody who's on the registry. We brought 3 separate claims on behalf of everybody on the registry, and those are all things that we won when we were in front of the district court the first time in Doe's 1. And so the first thing has to do with something called vagueness. Basically, it means that a law is so unclear that people can't follow it. And there the court said that the exclusion zone, so the restriction zone where people can live and work and so-called loiter, that those can't be applied to registrants at all because they're too unclear. People don't know where they can be, where they can live, where they can work. They're so unclear. And then the court also said the reporting requirements related to telephone numbers, electronic mail, and license plates are unconstitutionally vague too. So those would have to get revised. The second thing that we want on behalf of everybody is a doctrine called strict liability. And basically what that means is that if you make a mistake, if you don't understand what your obligations are, and SORA is a really complicated, hyper-technical law, and the court said you have to know that you're violating the law. Basically what this means is you can't be prosecuted for accidentally getting confused about what your obligations are. So that's actually a very, very important part of this decision. And then the third part of the decision that applies to everybody is that certain reporting requirements violate people's free speech rights, and those mostly have to do with telephone and electronic information reporting requirements. So those three parts of the ruling apply to everybody on the registry. What the court ruled for pre-2011 registrants, it made some additional and important rulings on that. And basically what we said in the Sixth Circuit had already said that you can't apply the 2006 and 2011 amendments to people whose offenses predate those. And what we argued and what the court agreed with is that the 2011 amendments, those were a total rewrite of the law. And so the court said you can't pull out the constitutional parts of those from the unconstitutional parts. So the statute kind of looks like Swiss cheese when you pull out all the parts that were added in 2011. And so there's no law that's currently in effect that you can really look to in terms of what people's obligations are for people pre-2011. And so you can't enforce the law at all for pre-2011 registrants. So that's a very important decision. Again, it basically says that the law can't be applied unless the legislature passes a new law. I want to make clear who's in that group. So whether you're part of the pre-2011 group depends not on the date of your conviction, but on the date of your offense. So to give you an example, if your offense was January 1st of 2011, but you were convicted in September 1st of 2011, you're still covered by the ruling on the ex post facto ruling because it's based on the date of the offense, not the date of the conviction. Okay. Talk a little bit about the next steps in the lawsuit, what's going to come next. So the next things in terms of the lawsuit are that the attorneys on both sides are going to work out the language of a final judgment. In the case, the judge is going to decide whether he's satisfied with what we write and make any changes he wants to make to it, and then he'll enter it. It will have a 60-day window in it for the legislature till it goes into effect. And then during that time, the legislature can be working on a new law. We have not yet heard any public statements about whether there will be an appeal, so we don't know about that. I think the really important thing is what's going to happen next in the legislature. Fundamentally, what the court did here on Friday was to say, legislature, you need to do your job. This law was ruled unconstitutional years ago, and you haven't passed a new law, and you need to write a new law. And there have been a lot of conversations, working group meetings, stakeholder meetings, trying to come up with a new law that different sides can agree to. And I think there's a lot of interest in having one law that applies to everybody rather than different laws depending on what the date of your offense was. In terms of our goals, we want to make sure that we have an evidence-based system that's really driven by what the research shows. And that would mean that we have many less people on the registry. It would mean that we have much shorter registration terms, a non-public registry, far fewer reporting requirements, no exclusion zones. So those are the sorts of things that we think are really important. but not everybody agrees with us. And so this next phase in the legislature is going to be really critically important. And we need your help with that. So we need your help in a couple of different ways. First of all, we need people who are willing to talk to legislators and the media about the terrible impact that being on the registry has had on them and on their lives. Sometimes there's opportunities to do that anonymously as well, because we recognize that not everybody's comfortable publicly sharing their story under these circumstances. Our legislative team has been working to train registrants and family members on how to do this. And if you're interested in helping us with this, we ask that you, again, email the intern@aclumich.org address. It's not a chance to retry your case or explain why you shouldn't have ever been convicted, but it's really a chance for you to talk about why it's hard, why being on the registry has made things more difficult for you to be a productive member of society in your community. And if you're interested in that, send us your name, your address with a zip code, your contact information, your age, the age of the victim at the time of the crime, your assigned number of years, and basic information about the offense, so that we can work with you on that. The second way that I think it's really important that we hear from you is that whenever there's legislation, it always involves compromises, and you never get everything that you want. We want to hear from you about what are the most important things to you, so that when we're negotiating about a new law, we can prioritize the things that are most important to the most class members. Only Michigan registrants, well, we have a survey that you can fill out. We ask that you only fill it out once, and it's only for Michigan registrants. If you haven't filled it out yet, send an email to intern@aclumich.org, and we'll get you a copy, a copy or a link to that survey. In terms of answering your questions, as was said at the beginning of the call, we will try to answer as many of your questions as possible. There are 44,000 people on the registry, and so it's very difficult for us to respond to everything individually. So please be patient with us. We're going to post information on our website. If we get questions, too many questions to answer individually, we'll be updating the public information in response to the types of questions that we're getting. But you can send your questions, again, to the intern@aclumich.org email, or by calling the 313-578-6829 number. Okay, just a couple more things, and then I'll turn it over to my colleagues. Wanted to say that if you have a pending criminal case involving a registry violation, you should talk to your criminal defense attorney right away about the impact of this decision on any such prosecution. We've also gotten some questions about recapture cases, about individuals who are looking at, facing registration or added to the registry as a result of a non-sex offense who were never on the registry before, but were added as a result of a non-sex offense. In our view, any new legislation could not include recapture cases. Let's see. We also strongly discourage people from bringing your own registry challenges to the registry right now. This is a class action, and so the court might not even allow you to bring your own case, but even if you did, because you had somewhat different claims, that could really complicate what we're trying to do for everybody on a class-wide basis. And for any registrants from other states who might be watching this video, I just want to emphasize that these are extremely difficult cases to bring. We had a terrific team who's worked on this case now for almost 9 years, and it's much easier to make a terrible law that will hurt a lot of people than to win these cases. So it's something that no one should take on lightly. Okay, so I think I'll turn it over to my colleagues at this point and see if they have anything to add that I haven't covered, and then we'll open it up for questions.
Great.
This is Paul. I'm now unmuted. Thank you.
Yes. Sorry, Paul.
That's okay. I just wanted to talk briefly about what happens next, because it's hard, I think, for people to imagine how political this process is, that is, writing a new law. Part of our concern while we were litigating Doe's 2 was that we wanted to try to have the rewriting of SORA process occur as far from an election cycle as we could. That is, if you can get the legislature to pass a law 18 months before the next time they have to run for re-election, you're likely to get a much better statute because the legislators will be less afraid of a reaction from their voters in their own districts if they look like they're getting soft on crime. I think you all know what I'm talking about. The problem that we face in the next few months is that because of the long delays in the case and because we were not able to reach a compromise when we were negotiating in the last year, it's going to be a much tougher sell with the legislators because we will be negotiating with them in March, April, and May with an election coming up in November. And so part of what this decision gives us and gives the legislature is an out, the ability to say to voters, yes, the new SORA statute is going to be less restrictive than the current one is, but it's going to be better. And by the way, the court made us do it. So what we need is for legislators to understand that there are 44,000 people on the Michigan registry and that those 44,000 people vote. That's what we're, maybe not all 44,000, but that many of them vote and many are interested in the outcome. What we want, we all know what modern social science research tells us. And what it tells us is that sex offenders have very low recidivism rates, and that the kind of third-generation statutes like Michigan's SORA that are in place and around the country now, we know that those don't work. They're hugely expensive. They don't help the police. They don't make the public safer. But that's something that the public and the legislatures need to be taught. And to the extent that you can help us get that message across, it can make a difference. I think the public and legislators don't appreciate how much harm a public registry causes and how expensive it is and how useless it is when it comes to actually making the public safer. We know that it simply doesn't work. And that's the message that we have to be sending consistently over the next 3 or 4 months. That's all I have to add.
Great, thank you so much, Paul. So I think at this point, we can transition into the Q&A. And Miriam and Paul, I'll keep you both unmuted. And
So Miriam and Paul, there's a lot of questions about who's going to decide if the new law that's written, if a new law gets written, is constitutional. A lot of concerns about the legislators trying to just simply rework the language and still make it unconstitutional. So that's one of a major theme through the questions. And then one of the direct questions is, how does the stance of the Attorney General help the case? And then there's 3 more questions after that.
Yeah, all right. I can take the first question. We have exactly the same concern. The danger with this kind of litigation from the start has been that you spend 9 years litigating, you win in the Sixth Circuit, you win in the Supreme Court, you win on remand back to the district court, and in the end, you get very modest changes in the statute, and you have to start all over again. And a second challenge will be very, very difficult to make because the worst parts of the statute, the most unconstitutional parts, will have been cut out. That's part of why I think it's so important that the next 3 months that we do as much as we possibly can to educate the legislature and the public. And that means individual meetings with every legislator. if we can get them. It means, if possible, having there be testimony in front of legislative committees so that people understand what I was alluding to before. But that's the risk. The good news is that the way that the legislature gets the most cover for an amended law is if it includes input from a very broad group of people. And that's what we were trying to do last year. When we say we were meeting and negotiating with the state, this was a group of 20 to 25 people that met, who met weekly. And it included people from the Department of Corrections, from the state police, from the governor's office, from the legislature, from the Prosecuting Attorneys Association, from victims' rights associations, as well as the plaintiffs' attorneys, and sometimes more. And even with that mixed group, we got close to agreement on significant changes to the statute. And in the end, why the negotiations broke down, we don't really know. We don't know if it was the legislature's movement that they were getting cold feet, that they thought it would be easier to pass a law after there was a court decision and they could blame the court. We don't know if it was the governor's office that maybe didn't have as much of an interest in significant change. We really don't know. But our hope is that we can get that group negotiating again, because it provides cover to the governor and to the legislature if they can say the state police have signed off on this, the Department of Corrections have signed off on this, the prosecuting attorneys have signed off on this, the victims' rights folks have signed off, and the plaintiffs' attorneys agree that this is the best law we can get. And so that's the hope, but we don't know if we'll get there.
The goal here for everybody is really to get to a point where we have a statute that we feel meets constitutional muster. And, you know, while we have disagreement with the state, we're going to have disagreement with the state about where that is. I mean, the way I explained it to the judge at the hearing is I think there's sort of a budget, basically. You sort of think about it as like, there's this much that the state can do in terms of restrictions on people. And if they go this far, they go way out here, that's too much. They can make some decisions about what they want to do within those parameters in terms of what kind of restrictions they want to impose. Do they want to have something that's based on individualized assessments, or do they not? How long are the terms? There's a bunch of different things that they could do. Ultimately, it will be up to the courts to make those decisions about whether or not the new law, if they pass a new law, is constitutional or not. And while they will probably take out the worst features, if they don't go far enough, the courts will, we certainly hope, say, hey, that's still unconstitutional. So I think the goal here, though, I think on everybody's side, is to avoid additional litigation. We've been at this for 9 years. It would be really, I think it would be, the state also does not want to continue litigating this. And so the goal is really to come to a political solution that really ratchets down the registry. And the question is whether we're going to be able to get there.
Yeah, I agree with that. I mean, the Sixth Circuit made clear that the constitutional calculation is basically two things. It's the harm to registrants versus the benefit to the state. And we've got a current statute that we know from the social science research doesn't benefit the state. It doesn't make communities safer, and yet it causes great, great harm. And so that's what we're trying to shift, is that balance. We want a statute that greatly reduces the harm and increases public safety. And if you do that, you also benefit the taxpayer because it will come at much lower cost.
So one of the questions was, how does the stance of the AG help the case? And another theme of questions is, what will happen if the legislature does not write the new law in the time allotted?
Go ahead, Miriam.
Sure. So I think the AG's position is very helpful because it recognizes that the state's chief law enforcement officer recognizes that this is punishment. And that is something that legislators can point to, that all of us in advocating can point to, that you have the chief law enforcement officer pointing to that. So I think it's a very important, very helpful development. And the second question was, remind me, Shelley?
The second question was, what happens if they don't write a new law in the time allotted? There's a lot of questions about that.
Right. So if they don't write a new law within the time allotted, the judgment will go into effect. Now, the judgment the opinion says that the parties can agree to extend things if they want to. That would require us to agree to that, though. And so if we were, a week away from getting a new law passed or something like that, that we felt was really good for everybody, that we thought was a good compromise, it's possible that we would agree to something like that. But we're not in the, it's a very different situation than we were in last summer, where the judge essentially said, if I'm giving you 90 days to work on this, and then if you don't, then we'll go back to court. What we have here is an order that is a final judgment that resolves the case. And essentially what will happen if the legislature does not pass a new law is that this decision will go into effect. And what that will mean is that there will be no law that applies to pre-2011 registrants, and that for post-2011 registrants, significant portions of the law, as I explained before, will not apply. So that's what would happen if the legislature does not pass a new law.
Great, thanks, Miriam. So the next question we've got is, if I get off the registry in Michigan, do I have to register in another state if I move?
So that's a great question, and that will depend on the law in the state to which you move. Every state law is different, and it's very confusing. What I would advise anybody, and this is true whether you have already gotten off the registry or whether this decision would take you off the registry, is before you move to another state, you talk to an attorney there, you talk to the sex offender registration board or unit or whatever it is in that particular state to determine whether you would have to register, because every state's laws are different, and it depends on the intersection of that state's law with Michigan law. So there's not one answer to that question.
Great, thank you. And another question we've got is, are there things that people in other states can do to help?
I think that's a great question. I think I think certainly helping us in terms of educating the legislature, making sure that the media, the national media, local media, that people are hearing stories about the harm that this causes and how divorced registries are from the purpose of registration. I think all of those things are really important in terms of keeping a national conversation going about why these registries don't work, and that can only help in Michigan. I don't know, Paul and Allison, if you have other thoughts on that question. It's a great question.
So Miriam, the other series of questions are really people asking about their own particular cases, and I'm just reminding people that we want to, we can't answer those questions here, but that we would want to keep a track of those questions. They should email the intern at ACLU MICH line. One other question that just came in is, do you have any thoughts on how the juveniles might be affected by this decision? So there are currently some juveniles on the private registry.
I think that, in terms of the legislative conversations that we've had, I think some of the individuals who have the most sort of sympathetic situations, those would be people who have, either juveniles, particularly juveniles who do not have the most serious offenses, people with expunged or set aside convictions, people with Homes Youthful Trainee Act some of those individuals, people with non-sex offenses, I think those are categories of people who are currently on the registry where I'm quite hopeful that we'll see some legislative change that will remove those people. Obviously, we don't know until we see what the legislature actually passes, but I do think that those are groups where there's significant interest, broad interest in not punishing those people unnecessarily. I would encourage people who are in those categories to really to come forward and work with us, because I think your stories are really the kinds of stories that we need to make legislators aware of just how bloated this registry is and how many people who are on it who it absolutely makes no sense.
Okay, Miriam, one more question that kind of keeps popping up. People are worried that if what ends up happening is that the pre-211, for instance, get removed from the registry, can the legislature come back at a later date and recapture them?
So the question is in what way that would happen, right? So let's say that the pre-2011, so let's say the legislature doesn't manage to get it together to pass a new law in the next 3 months. Which is certainly possible. But then down the road, they decide, hey, we want to add these people back onto the registry. I think that would provoke a lot of legal challenges, but I also would say that if it's a basic registration statute, it really depends on exactly what happens here. And I don't want to speculate because it's hard to know what the legal challenges would be because it really depends on sort of how that would work out over time. I think that the basic legal principles are that if you have just minor registration requirements, a first generation statute, you can apply that retroactively. If you have more burdensome restrictions that become punitive, you can't apply that retroactively. And that principle will continue, I think, to hold. At the same time, once you talk about people who were on and then off and then would go back on again, I think that would raise a whole series of additional issues. So I'm not going to speculate about the legality of that on a public call like this, but I do think that well, let's just put it this way. I hope that we see passage of a new law in the next 3 months, so that we don't have to worry about that.
Okay, 2 pointed questions. If we have people currently being prosecuted for a violation of SORA, where the violation could be implicated by the ruling, would you suggest we file a motion to hold these cases in abeyance pending the final disposition of the case?
So I think I certainly would talk to the criminal defense attorney, and I would, if I were a criminal defense attorney asking that question, I think I'd want to be consulting with my colleagues. I think there are there may well be very good reasons to ask to hold the case in abeyance. There may be other strategic things that you could do in terms of seeking to dismiss the prosecution. There are different kinds of what lawyers call estoppel arguments that may be applicable here. There are a lot of different legal options in those for those particular criminal prosecutions, and I would really encourage lawyers who are facing those, or clients who are facing those kinds of prosecutions, to also consult with the State Appellate Defender Office. They have been working on SORA litigation in the Betts case, which is currently in the Michigan Supreme Court. And because they do exclusively criminal law, they might have really good ideas about how to handle the intersection between this case, which is a civil case, and any current criminal prosecutions. I will say that because this is a class action, and because the court ordered notice to all prosecutors, prosecutors should be bound by this decision.
Okay, another question, Miriam and Paul and Allison. If there are no changes and the judge's ruling should go into effect, what will people's duty be under federal SORNA?
That is a great question. It's currently, there's currently a case that asked that question in the Sixth Circuit, and we'll have to see how that gets resolved. In our view, you cannot impose SORA obligations absent some kind of interstate nexus, meaning that the person is traveling in interstate travel where there's some kind of federal conviction, and that you also can't impose a duty that is impossible to comply with, where people can't actually register because there's no state law mechanism for them to register. But that is something that the courts are currently looking at.
Okay. Somebody says they can't hear you very well, but I can hear you really well. So let's see, hold on a second, because these are starting to come in pretty fast. There's just simply, you know, a lot of questions around living in other states. Well, people who have those questions about their own cases should write to our website.
And Allison wanted to make a comment, I believe, about questions that registrants have. Allison, I don't know, we can't hear you if you're speaking.
But you are unmuted.
All right, since we can't hear her right now, I don't know if there's a way to, Allison, for you to unmute yourself, but I will just say that Allison's office is also available to take calls from registrants about specific questions they have about their specific cases, and maybe we can put that number up when we post the call.
One more question, Miriam, that's popped up a couple times is the $50 fee that was, you know, that was just reenacted. There's a, I believe there's a cap on it, and I want to say it's 15. I can't remember how much the cap is now, but that the law had that is still in effect. That had nothing to do with the case. Is that correct?
We challenged that in the district court, but lost on that issue, and so there's not been a definitive ruling on it. But there, you know, unless the legislature, I would imagine that the legislature will. Well, we'll have to see what the legislature does with the new statute with respect to that.
Yeah, and just somebody corrected me. It's a $550 cap for that fee. So once you get to that point, that's been something we've been trying to get rid of for a while.
Yeah, I mean, part of what we're hoping is that there'll be shorter registration periods and easier paths off the registry, and you know, that's the easiest way to get rid of the fee, is not to be paying it because you're not on the public registry.
One of the questions is asking us if the state is very firm on maintaining a lifetime registration. I don't know if anybody wants to talk a little bit about what we've been experiencing in those groups.
I think the state recognizes that that's part of what creates the most harm for people, and I think the state understands from the Sixth Circuit opinion that if you create that kind of harm, you have to be able to show that the people to whom you're subjecting the harm pose a threat to the public. And that's a very hard thing for the state to prove the longer people are on the registry without having committed a new offense. And so our expectation is that lifetime registry will be reduced significantly in a new statute. That's our hope.
And then finally, a lot of questions on traveling for vacation. I don't think we have many answers to that, but there are a number of questions.
So the one thing I would say about that is that the 2011 amendments, which the Sixth Circuit said can't be retroactively applied, one of the things that they did was really change the reporting requirements, making it very difficult for people to leave for vacations by requiring all of this immediate reporting if you go anywhere for even a short period of time, and those kinds of things. Because
the court said that those 2011 amendments cannot be retroactively applied. I'm hopeful that we'll see a statute that will make it easier for people who are on the registry to travel.
So that, I mean, there are a lot of questions on people's individual cases, which I've been asking people again to write to the website. And I think that really covers most of the general theme of the questions being asked. So unless somebody has, wait, let me just look at these 3 new messages. So somebody asked a good question. Will the legislature listen to people who send their letters anonymously? And Miriam and Paul and Allison, you might want to talk about what kind of, well, maybe I can. We've been, this is Shelley Weisberg, I'm the political director, and we've been working on this for a number of years. And the legislature generally respects people's anonymity in this case. I think making a statement, though, as to why you're staying anonymous would be an important part of that message to the legislature.
I'll just note that Allison gave the number for the Oliver Law Group for people who want to call with questions there. They have some capacity to answer individual questions, and the number to call is 248-327-6556.
One more good question that I think you could answer for everyone, Miriam, is somebody is asking if all the amendments to the Michigan's Sex Offender Registry Act cannot be applied ex post facto, or just the 2006 and 2011 amendments.
So as I understand the question is whether there are other amendments from other years that cannot be applied retroactively. Is that what the question is, Shelley?
Right. In 1999, when a lot of people went public, there were some changes to the registry then.
Right. I mean, the Sixth Circuit decision said that the 2006 and 2011 amendments cannot be applied retroactively. That's the current ruling that we have. So it's focused on those 2 sets of amendments. And I think there are some legal arguments that could apply to other sets of amendments, but basically, in particular, the way that the internet is really changing, the impact of being on a public registry. But in terms of the legal framework that we currently have in the Sixth Circuit, its focus is on the 2006 and 2011 amendments.
So there was another request for the Allison's law firm number. If you say it again, we will put it on the post as well.
Okay.
And then for those people asking for who to address letters to in the legislature, I'm going to again refer you to our website, or Allison's law firm can help you as well, and we'll have that information there.
Allison's number again is 248-327-6556.
There's a question from a few people that asks if the law is overturned, will they get their filing, their $50 fees back?
I think that's unlikely.
Let me just look. Sorry, just looking. Yeah, I think looks like that's about the bulk of the questions. We've been answering them privately when we can. And so anyone who has any additional questions can continue to either go to our website or to Allison's phone number.
Great. Well, let me just wrap up then and just remind everyone of this sort of really critical important things that I said at the beginning, that we want to, you've got to remember that the decision is not yet in effect. And so you need to comply with SORA either until the decision comes into effect or there's a new law that's passed. And that we really want your help in trying to, this is an incredible opportunity. I mean, we've been working towards this opportunity for 9 years to get a change in the law, and we want to work with you to try to get as positive a law as we can. And then finally, I really want to thank that I know that it probably feels to many of you as if you're often forgotten and nobody cares about the really difficult things that you're experiencing as a result of being on this registry. And I want you to know that there have been a lot of people who've been working on this for a very long time to try to get to the point that we're at today. And I just want to thank those, my colleagues at the ACLU, not just in the legal department, but also in the legislative and communications departments who have worked really hard on this, the University of Michigan Clinical Law Program, and countless students over the years who've been involved in this, the Oliver Law Group, and Allison, who's unfortunately couldn't talk because something's going on technically today, but has been a really indispensable part of this. And I think most importantly, I really want to thank our clients in DOES 1 and DOES 2 who stepped forward to fight this fight on behalf of all of you. I'm deeply, deeply grateful to them for telling their stories and stepping forward. And I want to thank you all for everything that you're doing to try to change and fight against this really unjust law. So thank you.
Yeah, I'll just end by saying, we remain cautiously optimistic, and the amount of ground that we have traveled over the past 9 years really is unprecedented. There's no other state and no other federal court of appeals that has gotten the kinds of decisions that we've gotten in that time. And this latest decision is a major, major victory that all registrants should be happy about and proud of and energized by. It's a big boost for us going forward into legislative negotiations.
Sorry, I had myself muted. Thank you all so much for joining the call. And I am going to make sure that this gets posted to our website by tomorrow. And again, email or call us with your questions. Thank you all so much for joining, and we will talk to you soon.
Bye.